That's all that I have for the witness right now.
All right. Cross-examination.
And here we go.
Your Honor, for the record, I'm just putting 1AS back with Ms.
All right.
Winfrey, and I'm taking back the ones that were not admitted.
Thank you.
You're welcome. This is not.
Okay. I think that's it.
No, you're okay. Good morning, Attorney Wright.
Good morning.
I believe we met briefly to introduce myself yesterday or the day before, but again, I'm Doug Weinstein and I am Diamante Kendrick's attorney.
Yes, sir.
If I speak to you in a normal speaking voice, can you hear me okay?
Absolutely.
I don't need to yell or shout.
You do not.
Okay. We talked about proffer sessions, and a proffer session, again, I believe you said, is when a defendant meets with the state, correct?
Correct.
So to avoid legalese, I'm just going to talk about meeting with the state instead of using that word proffer. Okay?
Yes, sir.
All right. So if there would have been a meeting between Mr. Sledge and the state, you would have been there, correct?
Yes.
Was there a meeting between Mr. Sledge and Attorney Love before December 27th?
No, not that I have any recollection of. And I was, I never want to give an incorrect answer. So I was cautious, but I don't believe we ever actually sat down for a proffer.
Was there a meeting between a meeting between Mr. Sledge and Attorney Hilton before December 27th?
No.
Was there a meeting between Mr. Sledge and any member of the district, any attorney in the district attorney's office before the 27th of December?
Not that I'm aware of, no.
What about an investigator with the attorney's office?
No.
I have a slight objection just as to clarification because I'd ask that the meeting part based on other interactions, just vague. Was there any
The
meeting?
objection is vague.
Okay, let me clarify. When I've used the word meeting, what I mean is a proffer session. So to all of those questions, if I had used the word proffer session, were there proffer sessions?
I'm not aware of any proffer session that was ever conducted or even a more informal interview with anyone from the DA's office or law enforcement as it relates to this case.
So there being no proffer sessions, I believe you received the first proposed plea agreement on December the 27th with a series of factual acknowledgments, correct?
Yes.
So how in the world, to your knowledge, did the state come up with those factual acknowledgments for your client to agree to without having met with your client?
Your Honor, I'm going to object based on relevance and speculation as it pertains to how the state did something or came up with something.
Overruled.
I believe the state was trying to surmise through its overall
Well,
investigation.
now he asked your personal knowledge, so if you could answer that, please.
I don't have any personal knowledge how the state came up with these factual problems.
So you don't know how the state put those words in your client's mouth?
Objection as to the characterization of
Sustained.
Okay. How many plea negotiations have you conducted in your career?
Definitely over 1,000, maybe 1 to 2 or 1 to 3,000 over 30 years.
Okay. And these plea negotiations are like any other negotiation that takes place between parties, correct?
Absolutely.
There are things that you want in the final agreement, right?
Yes.
They're the things the state wants in the final agreement, correct?
Yes.
Do you get everything you want in that final agreement?
No.
And is this plea any different than the other pleas where you don't get everything you want?
No, it's not.
I have no further questions.
All right. Does anybody else have questions from the defense?
Attorney Wright, good morning, sir.
Good morning, sir.
Like Mr. Weinstein, you and I have known each other a long time, haven't we?
Yes, sir.
All right. Got a number of questions for you, and I want to break them down into separate parts, okay?
Okay.
And same ground rules. If you can't hear me, you don't understand the question, just ask me to repeat myself, clarify, whatever you need, and I'll be happy to do that.
Understood.
All right. Let me kind of start where Mr. Weinstein left off. Proffer session. It's been a reference, which is a meeting between your side, you and your client, and the district attorney's office. Never happened. True?
Correct.
Objection asked and answered.
Sustained.
All right. You did receive, as we've seen previously, that email with the proffer agreement attached. Is that right?
Objection asked and answered.
I did.
Sustained.
You have never seen, never received, and there is no signed proffer agreement.
Objection asked and
Anyway,
answered.
Sustained.
And your interest in representing Mr. Sledge would have been to try and gain whatever the best situation was for him. Isn't that true?
Objection vague and relevance.
Overruled.
Absolutely. In anything, the best interest of my client, that is tantamount. That is the absolute goal. I want not just keep them home, not just some things you might think. I want the best possible solution for the case.
In this case, in representing Mr. Sledge, you indicated you'd known him for well over 15 years, true?
Yes,
And at the time that you came into this case, you were aware of the indictment and exactly what he was charged with in the indictment.
yes,
You knew that he was charged with one count of RICO, or violating the racketeering in the RICO Act.
yes,
You knew that he was charged in count 30 of the indictment with possession of a firearm by a convicted felon.
I did.
The count 30, the possession of a firearm by a convicted felon, is something that he was accused of. The allegation was that he committed that offense in December of 2021. Is that right?
Yes,
Right. And that was included in the overall indictment with the RICO count. True?
yes,
Okay. Having represented Mr. Sledge before, you knew not just him, but you knew his family as well.
yes,
You knew his mother.
yes,
And so when you were in court over the course of the last number of days, and you heard testimony and questions about him wanting to get home to his sick mother, is it in fact true that his mother was ill?
yes. I have personal knowledge that at the time we were going over this stuff, that was something he expressed and was stressed over.
That was a concern of his.
Yes,
You knew, and I want to kind of reference some dates. He was arrested somewhere in June, around June of 2022. Is that right?
that's, I'm relying to some extent, but I'll say to the best of my knowledge, yes.
Well, you know that the case was indicted. The indictment was handed down in May of 2022.
Actually, that being the case, yes, he was arrested not long after.
Okay. You, and I don't want to delve too deeply into it, but you shared that at least in the early part of that, you were having some health concerns yourself.
Yes, and let me back up a little. The reason I paused on my answer was, remember, there was sort of an earlier part where he at some point had charges related to this. Those charges ultimately went away. Then much later on, there was an indictment and then an arrest. That's why I sort of paused, because that earlier date is not immediately known to me. But as to once this case was indicted, then the arrest, even though I was not back to my practice yet, I was aware of it and was sort of watching from the sidelines.
Okay. You were in court and heard when he was testifying about that previous matter you're referencing. In other words, his arrest and where he was charged with the murder of Donovan Thomas.
Correct.
And so at the time that you come into this in 2022, you have knowledge that detectives with the Atlanta Police Department had previously charged him with Donovan Thomas's murder and then ended up dismissing him or dismissing the charges, right?
Objection, relevance.
Goes to his
Overruled.
Yes, that's the point. I was aware from before. So when this occurred, it wasn't necessarily something new to me. I was already aware that there was some history.
Okay. You mentioned a couple of dates when you were testifying earlier. We talked about you getting into the case somewhere around October or November of 2022. Is that about right? And when I say get into the case, when you were healthy enough,
Correct.
to kind of resume your practice and get into Mr. Sledge's case.
Yes, sir.
Okay. By the time you would have interacted with him or started representing him on this case in either October or November of 2022, he would have been in jail for a number of months, true?
Correct.
He would have been in jail at the Fulton County Jail, true?
Correct.
And since he was in jail at the Fulton County Jail, that presupposes, and you know, that he did not have a bond.
Correct.
Now, if you're in jail and you don't have a bond, you stay in jail, true?
Correct.
The only way you get out of jail, if you're in jail without a bond, is you either, your case gets dismissed, right?
Correct.
Or you negotiate some sort of plea or deal that gets you out of jail, right?
Correct.
Or you go to trial and you get acquitted and that gets you out of jail.
Correct.
Mr. Sledge wanted to get out of jail.
Yes.
He had been in jail for a number of months by the time you spoke to him, and he was anxious about getting out of jail, wasn't he?
Objection, counter, asked, answered, and
Sustained.
He discussed with you his desire to get out of jail, true?
objection, asked, answered, and it gets into,
Attorney-client privilege.
yes,
Sustained.
Were you attempting to get him out of jail?
Yes.
All right. Now, Mr. Sledge, you were in court previously when there was some discussion about what an Alford plea is that right?
Yes.
All right. Now, and one of the ways that a defendant, Mr. Sledge, could resolve a criminal case is with what's called an Alford plea, right?
Yes.
Now, an Alford plea, as you would have discussed with Mr. Sledge in one of his previous cases, revolves around someone saying, I'm not guilty of the charge, but I'm going to plead guilty because it's in my best interest. Is that right?
Correct.
Right. And you would agree with me that entering a plea of guilty, whether it's under Alford or just a straight guilty plea, can sometimes be in a person's best interest, right?
Oh, absolutely.
And that may sometimes be regardless of whether they consider themselves to be guilty of the offense or not.
objection,
True.
Your Honor, relevance.
Correct.
Overruled.
Correct.
Because as you've testified previously, people enter pleas for different reasons. Isn't that right?
Correct.
You having, were you the one who did Mr. Sledge's bond hearing, or was it another attorney?
It was probably me. I just don't have it was a while ago. So.
Okay. It was in late 2022. True?
Well, you know what? No, his arrest on this, I wouldn't have been able to do the bond hearing. So I'm not sure who represented him for the bond hearing as it relates to that June arrest.
Okay.
I was thinking of the old case, but as to that, I would have to say, no, I was still on the sidelines where I wasn't cleared to practice yet.
Right. One thing that you became aware of, though, when you came onto the case in late 2022, is that, as you indicated before, Mr. Sledge did not have the resources to go to trial.
Correct.
And it is true, as he testified. Did you hear his testimony about that?
I did.
And did you testify also earlier that you knew that he had limited resources and he just didn't have the resources to take this case to a year-plus trial, right?
It was something that was heavy on my mind in terms of when I'd be able to return to practice, to be able to assist Mr. Sledge, because knowing he had limited resources. And even, I guess, because of the relationship over the years, even though he didn't have the resources I would have liked to become involved in this case, I was going to do what I needed to do to help him. And therefore, even though it wasn't, a huge fee for, or resources for a big year plus whatever kind of trial, I wanted to get involved, make sure I'm here to get him out of this situation and help him in this case. So I know that was a long answer to your question, but yes, it was something actually heavy on my mind, which made me say, let me get back, be healthy and effective in making sure I can represent him.
One of the things that you would have discussed with your client, with Mr. Sledge, would have been the risks of going to trial. Is that right?
Yes.
That is certainly something that you would have counseled him to consider in regards to what decision he made. True?
Yeah, every client, we're going to have that conversation.
It is true that you would have counseled him that, hey, look, Mr. Sledge.
Objection, Your Honor, when it gets into specifics of the risks that Mr. Wright considered existed in this case, I think that is privileged information unless now Mr. Sledge has waived.
All right, well, Mr. Wright understands the obligations of the attorney-client privilege, so please do not reveal any attorney-client privileged information.
And I was going to say, I cannot answer that question because you're asking me something specific to Mr. Sledge.
Sure. What you knew, though, is that had he gone to trial and been convicted, he would have been facing a potentially long period of time in prison.
I would say I would know for any of my clients that when you're facing these kind of charges, the potential consequence of a conviction could be a very lengthy sentence. So it's extremely serious. So you want to make sure you can stand guard and do the best to make sure you get the best result for your client.
And that is something that you would, without going into any specifics, that is a factor that you would have discussed with Mr. Sledge. True?
Again, not specific to Mr. Sledge, but to all my clients, to make sure that their eyes wide open. We talk about the good, the bad, all the possibilities, so that you can make sure as an attorney that my clients have a full understanding of the risk, the reward, and all the possibilities in between, so that they make an informed decision on what they want to do.
You were aware, were you not, that the state, the district attorney's office, was interested in whether or not your client would testify, would take a plea and testify? You knew that, didn't you?
Yes, as of, I think the first email was sometime in November, when sort of the first communication that sort of gave us an idea that they would like to talk to him.
Were you ever present in court where any representations were made by an assistant DA that we're looking to make deals?
I first appeared in court in middle of December. That's sort of when I came back, but I also appeared on behalf of Mr. Sledge. I don't remember the details of what occurred that day, but I will say when I reached out to the state to say, hey, let's talk, it was middle of December. So it was after, I think, that first couple court appearances in December.
Okay. It would have been after, also, there was that November 30th correspondence between you and the state. True?
Correct. I had not yet responded to them, but it was in middle of December that I essentially was now responding to them and saying, okay, well, let's talk.
And that November 30th email was an email that you received from the state.
Mhm.
It was unsolicited, true?
It's easy when you have emails to say, I remember this. It may have been a phone call where it is customary that even though you may see us in court, everyone seems to be one side or the other arguing. Professionals, we call each other, we talk, we communicate about different cases we may have going on. So it was not unusual for Ms. Love or someone from her office to just reach out, call me as sort of that first step. And I think there might have been a phone call followed by that email. But again, I just don't have a recollection of a phone call or what the conversation is, but it wouldn't have been unusual. I've known Ms. Love probably 10, 12, also maybe 15 years.
Okay.
So as one professional to another, it would not be unusual for her to reach out to me to basically see, is my client interested in something?
Now, during that period of time, from November 30th to whatever it was you reached out to the DA's office, or having some conversations with them, you would have been talking to your client about what he wanted to do in regards to resolving the case, true?
With all
Can you
my
move back towards the mic, if you don't mind?
Yeah, with all my clients, I'm going to communicate to them, hey, here are communications or statements or developments, anything about their case. So again, not talking specific with Mr. Sledge conversations, it is my norm and usual that if the state reached out to me, I would have made sure to reach out to him. And more often than not, I don't like jail phones. So I don't want to be listened to. So I will try to go see my clients and have that conversation.
At the jail?
At the jail.
I want to backtrack a little bit and ask you, you testified just a moment ago that you weren't sure as to whether or not you represented Mr. Sledge at the bond hearing in regards to this case. Is that true?
Yeah, I just don't have a memory. I may have, but I may not have. I just don't want to misstate something.
Would it help to refresh your recollection about whether or not you represented him at the bond hearing if I were to show you a document?
Absolutely.
Can I first witness, Your Honor? Yeah.
Yes, please.
I was going to show you for purposes of the record what I've marked as defendants Williams Exhibit 257A and 257B respectively. I'm going to go ahead and put those to you, let you take a look at them, Mr. Wright, and once you're done, you just tell me whether or not that helps to refresh your recollection as to whether, as to who represented Mr. Sledge at the bond hearing in this case.
Yes.
Okay.
Seeing this, it does refresh my recollection.
Okay. So tell me if you would, whether or not you did in fact represent Mr. Sledge at the bond hearing in this case.
I definitely filed for bond, and I either represented him myself or I had someone stand in for me if there was an actual hearing, because I'm not sure in that time frame that I had filed for it whether I had been cleared. So I can at least state I filed for it and I either was there and represented him or I had an attorney stand in my place.
When the bond was denied.
So it's still on me. Yes.
Okay. All right. So let's jump back to December now, right?
Okay.
So we're in December, and if I heard you correctly, the state has sent you an email on November 30th. And so now you're talking to your client in mid-December to see what he wants to do in regards to the case.
Okay.
All right. At some point, you end up in court, and I'm focusing now on December 27th, December 28th,
Okay,
because the plea was entered on December 28th, true?
correct.
All right. The correspondences that were shown to you, well, we've been using the word iterations of this so-called plea agreement. The first one came to you on December the 27th, isn't that right?
Yes,
And so the very first time that you and or Mr. Sledge would have had an occasion to consider the state's proffered plea agreement was one day before he entered his plea. True?
yes, and to give you detail, that day, I actually, once I received it, went to see him to go over it. And then ultimately, it's when I got back that I sent the response. So that's why you can see I received it around 5 or so in the evening. I didn't respond until about 8 or so at night because I needed to basically go talk to him and get his feedback. And
So-
ultimately, I then sent feedback back to the state.
All right. So we're talking now about maybe 4 or 5 o'clock p.m. on the evening of the 27th is when you first received from the state this plea agreement that they had drafted up, right?
Correct. That the first one. Yeah.
Right. And again, this plea agreement that they sent to you with the different paragraphs and provisions was something created by them, not by
Objection,
Mr.
Your Honor,
Sledge.
asked
True?
and answered.
Sustained.
And when you went to the jail to meet with Mr. Sledge on the 27th, this would have been the first time that he had any opportunity to look at anything called a plea agreement. True?
Correct.
You would have discussed this plea agreement with him. True?
Well, again, not specific communication
Sure.
for Mr. Sledge, but with all my clients, I'm going to take the plea agreement and go over it with them. So any meeting where a plea is ultimately in the air and being discussed, that yes, I'm going to go get my client's feedback.
So by the time you see him on the evening of December the 27th, 2022, you've got a plea agreement with you, and you're going to have a conversation with him about whether he wants to take this plea, right?
Correct.
Okay. There's still, of course, the option of him going to trial. True?
That remains an option unless and until he takes the plea.
But hanging in the air at that time with the plea agreement on one side and potential trial on the other side was his concern about getting out of jail to see about his sick mother. True?
Objection,
Yes.
asked, answered.
Sustained.
Also hanging in the air was the possibility of him not having the resources to go to trial. Right?
Objection, asked, answered.
And as you would do with any client, you'd have discussed whether or not there were things in that plea agreement that the client simply could not agree to or would not agree to.
Objection,
Sure.
asked and answered.
Overruled.
I would say again, not specific to Mr. Sledge, but when a client reviews a plea agreement, if there are factual allegations, because there's not always factual allegations in the plea agreement, but if there are, we're going to go over those. And if we go over those and there's some disagreement or there's some need for clarification, that's something that I will go to the state and indicate, hey, there's some issues here. We need clarification or changes or what have you so that we can make sure these are accurate.
And in this case, you actually did that, didn't you?
I did send an email to the state indicating that there are some clarifications that we would like.
Okay. So there's some negotiations now going on, or some correspondences, communications going on back and forth between you and the state, you on behalf of Mr. Sledge and the state,
Yes.
from the 27th of December, carrying into the 28th of December, the next day.
Yes.
The next day, he's actually in court.
Yes.
He's brought into court and you have an opportunity to talk to him in what, a holding cell, a holding area? Outside?
Yes.
Okay.
He's in a holding area where, and it's typical a lot of times that client will be one place, the state may be in here or in a conference room, and I'm sort of the messenger of sort, going back and forth to help facilitate a negotiation.
You had the opportunity to discuss with the state that there was a factual allegation in their plea agreement that you did not want, or you wanted changed. Remember that?
Correct.
You talked about number 3.
Correct.
Now, the subject matter of that number 3 revolved around
Your Honor, I object as to the characterization of the number 3, and I'd object based on vagueness. Are we talking number 3 in 1AS or number 3 on one of the other exhibits?
Sustained.
all right,
Check out the final version.
yes, let's reference what ends up being the final version of the plea agreement. I believe that states 1AS. Okay?
Okay.
Do you have those in front of you? I want you to be able to refer to them.
I do not have that in front of me.
No.
Okay, my question is,
You may.
all right. Mr. Wright, I'm going to give you what's been marked as states 1AS. And I've got some questions I'm going to ask you referring to that document, okay?
Okay.
You had a chance to see what would ultimately become stage 1AS and the conditions, the provisions, the factual acknowledgments that were part of that document, true?
Yes.
Okay. Prior to the execution of that document on the 28th of December in court, you had an opportunity to communicate with the state that you had a problem, or y'all had, to use your words, some concerns about that factual acknowledgement, right?
Yes.
Now, that factual acknowledgement revolves around this incident about a video where Mr. Sledge is alleged to have been in a video holding a gun, making threats to someone else, to another person, correct?
Correct.
When the state presented any of the iterations, including that last one, right, of the plea agreement, they wanted Mr. Sledge.
Objection as to what the state wanted.
Sustained.
The factual acknowledgement revolved around Mr. Sledge acknowledging that while associated with YSL and to support and express loyalty to YSL, the defendant, that would be Mr. Sledge, and co-defendant Demikian Garlington and Quindarius Zachary appeared in the video with another person. AS, wherein defendant brandished a weapon used in a drive-by shooting and wherein on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, girlfriend. That was the factual acknowledgement, correct?
That was the factual acknowledgement, yes.
You communicated with the state and you requested that they change that, correct? Or that it be removed.
Your Honor, objection is to compound.
Yeah.
And I don't,
Sustained.
They did not change it.
Your Honor, I object and ask that whatever question there was.
Can you pose a question?
Sure. When you saw that factual acknowledgement in the manner that I've just read, in any of the iterations leading up to the 28th, you communicated with the state and asked them that it be changed. True?
Yes.
They did not change it. True?
No, they did not.
Mr. Sledge still initialed that, correct?
Correct. And that's an example of sometimes, as other counsel has asked, you try to get everything you want in a negotiation. Some things you may have to live with. And ultimately, this was an item where someone could try to argue whether two things are true at the same time. That is this just a boy-girl and another boy issue, or is it a YSL issue? But a decision was ultimately made that if it wasn't getting changed, we either had to live with it or stop the process. And ultimately, that stayed.
But the reason that you wanted it changed,
Hold on.
when you spoke to the state, you told them that that information was not accurate. True?
True.
You told them that this wasn't the factual acknowledgement that referenced it being done on behalf of YSL, that was not true. This was about a girl.
Your Honor,
And not
objection
about-
as to the compound nature of that question.
Sustained.
You told them that that incident was not about a gang-related incident. True?
True.
You told them that it was about a dispute over a girl. True?
True.
But they did not change it.
Objection asked and answered.
Sustained.
Were you present? You were present in court when Mr. Sledge testified that he thought that he would have an opportunity to, notwithstanding his initials, explain his answers if put on the stand. Did you hear that testimony?
I did.
Did you again, without going into any privilege and to your observation, well, actually strike that. Did you have a conversation with the state about whether or not Mr. Sledge would be able to explain anything that he had some disputes with in the factual acknowledgments?
The conversation was had back when we were doing the plea, and then even since then, it's always been broadcast or at least made clear by me, hey, if there are some differences in some of the content of some of these, my client will ultimately want to explain. If you put him on the stand and he testifies, he's going to want to explain what he means, as is when he acknowledged this, because something can be true, but also be true with other components to it. It's not always just one way that one person sees it as opposed to how another person sees it. And he wanted to be able to at least explain that. I think he often referred to it as his truth. And that was really him just wanting to explain.
You discussed that with the state.
Yes.
Objection asked and answered.
Overruled. You can answer.
I would say yes. And again, sometimes the state would agree and they would make changes. Sometimes they would not agree. But it is incumbent on me to make sure, hey, eyes wide open, full disclosure, we've told you. So it was not going to be a surprise that, well, Mr. Sledge may have a difference of opinion.
It was your observation that the state wanted this plea to go through as much as Mr. Sledge did. Is that true?
Objection, Your Honor. Relevance is to, and speculation as to what the state wanted.
Wasn't what he asked. Overruled.
True.
I had a belief.
Okay. That's also not what was asked.
Okay. Well,
Maybe ask your question again.
And relevance as to what the state wanted.
Based upon your conversations with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement, you formed or you observed that the state was just as interested in getting this plea done as Mr. Sledge was. Isn't that true?
So objection.
Go ahead.
Objection. It calls for speculation about the state, and whatever his observation is or belief was is not pertinent to any material.
Sustained.
Was it your observation that the state wasn't really concerned with Mr. Sledge, they really
Objection.
wanted Mr. Williams?
Same oh.
Sustained.
That's crazy. And I have a motion as it relates to that.
Sustained. Ask your next question.
Okay, I thought you were waiting on the emotion. All right. Before Mr. Sledge was brought out into court on that video that we saw and entered the plea, I know there wasn't a proffer session, but separate and apart from that proffer agreement, the one we talked about earlier that was mailed to you, did you ever get an email from the state saying, hey, we want to talk to him before he enters the plea?
I'm not sure if they asked, but on the same token, my client never expressed an interest in talking to him. So I can't necessarily say it was the state or the defense that kept that conversation from happening. Ultimately, the conversations really were just the negotiations back and forth.
Okay. I got a question I want to jump ahead and ask you about first and then come back to the plea. So the plea is entered on December 28th, 2022, right?
Yes.
You had that meeting that was talked about on June the 9th of 2024,
Correct.
right? At any point between December 28th of 22 and June the 9th of 2024, did the state ask you to bring your client in for an interview?
Objection, Your Honor, relevance.
I don't believe so. I know we didn't meet with the state until we ultimately did in June of this year. But we always just sort of figured we were standing by, and it was always our hope we weren't going to have to testify. So we were hoping, hey, we're on the sidelines and we're no longer relevant in this. And then ultimately it was this year that they said, we need to sit down with you, and yes, you will be testifying.
In 2024,
In 2024.
in the middle of the trial.
Objection, relevance.
Sustained.
Okay. How about this? Did the state ever send you any questions that they might want to ask your client?
Objection, Your Honor.
Yes.
Relevance as to whether or not the state ever sent any questions.
All right, so move on to your next question.
You knew when the plea was entered in December of 2028 that Mr. Sledge was a potential witness to be called to trial. Is that right?
Correct.
Okay. And after he entered the plea, he got out of jail. True?
Correct.
Objection, asked and answered.
Sustained.
He didn't just get out of jail as a result of entering the plea, though. Am I right? There was a bond component of that also, wasn't there?
There was, but
In fact,
Your Honor,
There
I
were
ask
two-
that the witness be allowed to finish his response.
Yes.
I'm sorry. I thought you were done. Go ahead, sir.
well, I was going to say, I think the bond, we worked that out as part of the plea as well, so that was not going to be an impediment to him getting released. So in other words, it really sort of was all connected.
His plea was on count one, the RICO plea, the RICO charge, right?
Uh-huh.
He also pled guilty on count 30, the possession of a firearm by a convicted felon charge, right?
Correct.
He was sentenced on count one
Correct.
His sentence on count 30 was left open until after this trial concluded, correct?
Correct. In my practice, I find that it is not atypical for states when they do enter into an agreement with a defendant to try to have something held over so that the defendant's participation, they can make sure the defendant just doesn't show up and show out. They come and do what they indicate they're going to do. And therefore, count 30 being held open was not atypical.
Right. His plea agreement and his plea required that if called to testify, he come in and he testify truthfully,
Correct.
consistent with the plea agreement, correct?
Correct.
Because count 30 was left open in terms of sentencing, he couldn't get out of jail unless he got a bond on that charge, true?
Correct.
The state consented to a bond on count 30, didn't they?
Your Honor, I'm going to object as to characterization, and the court can check, and I will not speak on evidence, but I believe that this is a matter that.
All right. How much longer is your cross going to be? Because we're approaching the lunch hour.
More than half an hour.
Okay, let's break for lunch.
I should grab them.
Thank you very much. Y'all be seated, and Mr. Adams, you can continue your examination.
Thank you. Mr. Wright, welcome back, sir.
Thank you, sir.
All right. I think when we left off, Attorney Wright, I was asking you, we had gotten to the point where I was asking you questions about the actual plea on the 28th of December. Okay. So I want to pick up there. All right. At the end of everything, all of the discussions, the plea agreements, conversations with your client, ultimately, Mr. Sledge entered a guilty plea, correct?
Yes.
And he was sentenced, at least in part.
Yes.
And he was released from prison, from jail, true?
Yes.
All right. Part of his sentence, requirement of his sentence was he had a curfew. Is that right?
Maybe so. I'd have to refer to it, but that sounds
Okay.
reasonable.
10 to 6 sound like what you remember, if you remember that?
Again, if the curfew was in place at the time he first got released, yeah.
Okay. It's fair to say that even after he had entered his plea and had gotten out of jail, he had conditions on him pursuant to his plea and sentence, true?
Correct. And it was always an unknown, is he going to have to appear, testify, and, go through this?
But that was, of course, something that was, and I'll use the phrase hanging over his head. That was a condition that was upon him.
Yes.
The possibility of him testifying, true?
Yes.
And of course, the discussions that you would have had with the prosecutor and with your client, again, I'm not asking you specifically what you told him, but subject matter is that if he were to testify, it would be expected that he would testify truthfully and consistent with that plea agreement, correct?
Correct.
All right. Now, it would be fair to say, and you tell me if I'm right or wrong, that you would, of course, make him available to speak to either the state and or the defense in preparation for his testimony.
Correct.
And previously with other clients, and I presume with Mr. Sledge, it would have been incumbent upon you, and you would have discussed with him the necessity of testifying if he were to be called in, testifying truthfully, correct?
Correct.
You've heard the phrase before. He's used the phrase, and it's been here in court, where he said he was of the impression that he would be able to get up and testify to, quote, his truth. You heard that?
Correct.
Okay. You knew and you understood, based on the discrepancies that you had with the plea agreement, that his truth might not necessarily agree with the verbatim reading of the plea agreement.
Objection vague
Knew it was coming.
as it relates.
Sustained.
I'll rephrase the question. You knew that he did not agree with everything that was in the plea agreement, correct?
I understood that he did have issues with some of the factual allegations that were contained in it. Yes.
Okay. And so moving forward then from that period of time, December of 2022, to when the state made contact with you about speaking to Mr. Sledge in June of 2024, you made him available at that time, true?
Yes.
And if I heard your testimony and the testimony properly, this was a meeting that took place at the Starbucks over in Fayetteville, correct?
Yes.
Would have been yourself, Mr.
We've
Sledge.
gone through who it was.
Asked and answered.
Sustained.
All right. You testified that the meeting that was had with Mr. Sledge at that time was approximately 40 minutes. Is that accurate?
Objection asked and answered.
Your Honor, I'm entitled to a thorough and sifting cross-examination. I'd like to be able to explore that because it has been made an issue by the state in their questioning.
Okay, I don't know that the length of time of the meeting has been made an issue. Just go on to what it is that you want to get to with this witness and questions.
Yes, Your Honor. Did you describe in your previous testimony this meeting as a getting to know you sort of session?
Yes. It didn't seem like a detailed question answer preparation kind of meeting. Is more of a feeling each other out, getting to know you kind of meeting, and giving you a general idea of, hey, you're going to be testifying, and therefore, I'll be asking you questions, and so we need to get a sense of each other.
Was there a discussion from the state did they advise Mr. Sledge of what they would be asking him?
No, there were general questions again, but it was not often when you think about witness prep, you think, hey, got 20 questions here. The 20 questions it wasn't anything like that. It was really more of a introduction to each other, get to know you kind of meeting.
It did not appear to you to be what you would consider a witness prep session.
Correct.
And that was on June the 9th of this year, correct?
Objection asked, answered.
Sustained. Mr. Adams, go ahead and just focus in on what it is that,
Wow.
we're all familiar with what he's already testified to.
Wow.
Anytime after June the 9th of this year, and when Mr. Sledge was brought in to testify, did the state ever, in fact, conduct a prep session with him where they asked him or discussed questions they might ask him on the stand?
Objection
No.
relevance.
Overruled.
No. That was, like I said, we met the one time, and then we've appeared for trial. And to be clear, we appeared to trial a couple times, but we weren't called, but they did not ask questions or anything. We just sort of waited.
Mm-hmm.
So again, trial was really the next instance of any communication between the state and my client.
Did Mr. Sledge at any time ever indicate that he would not comport with his plea agreement and come in and testify? Did he ever exhibit any reluctance to come in and testify?
No.
Did he ever attempt to avoid a subpoena or to avoid reporting when he was asked to
Objection
report?
relevance.
No, in fact, for us, in our posture, we wanted to make it clear if they need to meet with us, see us, when we need to come in, we were always going to make sure we are there and make ourselves available so that at all times it's clear we're fully cooperating.
During the course of that meeting, you described, and I'm going to use your words, that when Mr. Sledge started talking about what Jeffrey Williams had said about taking Woody down to see the police, that, quote, the prosecutor didn't seem to like that topic. What
I said then were words to the effect, and I'll say it again now, that she made it clear that wasn't what she asked him, which is true. That wasn't the question that I heard her ask him. But ultimately, my observations were that it was a topic that she wasn't asking about. And again, it just sort of raised a red flag for me that, is this a hot topic? There's something to that.
When Mr. Sledge testified that the prosecutor said to him, quote, I'm not going to ask you about that, do you have a specific recollection of him, of that being said?
What I can say is, again, I didn't hear Ms. Love say that, but I do know my client indicated that's what he heard. So we were both present, but we heard things differently. So yes, he has always contended that's what he heard. And again, to the extent that what I heard was not the same.
Did he contend that prior to him being put on the stand? Let me rephrase that question so it's clear.
Okay.
You heard his testimony when he testified to that on the stand, am I right?
Yes.
Had he indicated that to you, that sentiment to you, that that's what he heard prior to him coming in here and testifying?
Yes.
I want to, almost done, just have one or two last questions for you, Mr. Wright. I want to jump back to early December of 2022, when you were having the back and forth with the state.
Okay.
In regards to the plea agreement. And if I heard you correctly, that was between essentially the 27th and 28th, is that right?
Yes.
Do you recall stressing to the state or sending them a message, specifically telling them that you were ready, he was good, Mr. Sledge was good to take the plea, he didn't want any media, and that he just wanted to get back to his family? Do you remember expressing that sentiment to the state?
I did.
One moment, please. Attorney Wright, thank you. That's all I have at this time.
Thank you, sir.
Thank you. Mr. Sharp.
Good afternoon, Mr. Wright.
Good afternoon.
Attorney Wright.
Good afternoon.
May I approach to just see what the witness has in front of them?
You may.
This is 1AS, which was that final. These are just my own little notes. This shouldn't be. These are all just my own notes.
Yeah, over here.
Okay,
I'm just gonna put these in front of you.
sure.
So you're handy. Thank you, Your Honor. Okay. Attorney Wright, on direct examination,
Mhm.
you made reference to identifying a portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several,
Mhm.
but there was one in particular that the state changed for you, correct?
I need you to give me a little more info
Okay.
on which one.
And I'm not going to get into the contents of it, but it's in what's been marked 455Y.
Okay. Hold on. I'm not seeing 55 for me. One more time. 6.
State's just handing it to me.
Okay.
Good approach.
Gotcha.
That's what they got.
It is.
I believe that's 455Y.
Yes.
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 Now, we're throwing a lot of numbers at the jurors.
Okay.
Just so we know what we're talking about, 455Y is not the final plea agreement with the final factual acknowledgments, correct?
No.
Okay. On 455Y, on factual acknowledgement number 8 on that document, not the final document, but number 8 on that document, isn't it true that you identified that factual acknowledgement and said that you had some problems with that factual acknowledgement? And I'm specifically the last part of it.
Yes.
Okay. Now, as the attorney in this case for Mr. Sledge, you received discovery, correct?
Yes.
And you were able to see what your client may have said or did not say to any police officers.
Correct.
Okay. And certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys.
Okay.
And you're aware, you would be aware of what your client would have said to any district attorney investigators, correct?
Yes.
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it. Okay? You with me?
Yes.
The state removed it. We agree?
Yes.
Okay. That part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing, correct?
I can say that my client never said or adopted that statement, and that was one of the reasons he asked it to be removed.
Okay. And I understand he didn't adopt it, but to your understanding, he never said it.
Correct.
Okay. And that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection asked and answered twice.
Oh,
That's correct.
Okay. Thank you. I just want to talk to you about the timeline of you receiving the plea offer and in actual pleading this case, okay? You received the first version of the factual acknowledgements, you would agree, at approximately 5:00 p.m. on December 27, 2022?
Yes.
Okay, and that was the day before the plea was entered.
Correct.
And as I understand, I'm not going to belabor the point, as I understand, you went to 901 Rice Street the Fulton County Jail to discuss the plea offer with your client.
Yes.
Okay. Mr. Sledge. And do you recall how long you met with him that day?
Now that I don't know. It would have been long enough to make sure we're going over things for me to get a good idea of what his response would be to our conversation and the things I was going over with him. And then at some point I would leave. And then, of course, as I said, later prepare a response email to the state.
And this meeting with your client, was this you were in the attorney booth at 901 Rice Street?
Yes.
Okay. And as an attorney, or when you met with Mr. Sledge, you were on one side of the booth. There's a glass.
Objection, relevance is to.
I'm discussing their ability to go over this document. There's a thick glass barrier in between you and Mr. Sledge for this meeting.
Correct.
And he's on the other side of the thick glass, correct?
Correct.
And of course, you have to talk loud, but you can hear each other, correct?
Correct. And let me at least so you know, because this is some time ago, I'm assuming I was, again, because we are almost always in the attorney booth. We get a little key, we can unlock it, we can go in. We can also hand documents back and forth.
Right.
That is my recollection of how I met with him, which meant I would have been able to hand him a copy so he can read it, I can read it, at the same time and go over whatever we need to go over. I'm sort of stating it because it's so long ago. Is it possible that I just saw him through one of the more window only kind of things where I could not have handed him stuff? Possible. I don't remember that. I remember being in the attorney booth.
Okay.
But I just wanted to point out that, yes, we can talk as well as hand stuff to each other to review.
Well, let's let the jury know what we're talking about here.
Yeah.
So if someone's in the attorney booth, if it's being used, if it's occupied, you can use a visitation booth, correct?
Correct.
And that also has thick glass in between you and the person you're speaking to, correct?
Yes.
And the main difference is there's no pass through in those
Correct.
booths.
Again, all audible stuff's the same, but you just can't pass stuff back and forth.
Okay. And of course, when you met with him on the 27th, met with Mr. Sledge on the evening of the 27th, you had whatever version of the plea agreement was in effect at that point, but not the final version.
Correct.
Okay. All right. Could you refer to 1AS?
Okay.
For me?
I have it, sir.
Okay, thank you. You would agree that in the negotiations with the state, your client pled to count 1, which was conspiracy to commit RICO violation, correct?
Yes.
And he was facing 15 years to serve. He was sentenced. The agreement was 15 years to serve on probation, correct?
Correct.
Okay. And then count 30, he did plead guilty, and according to this agreement, sentencing was withheld
Yes.
and would be dismissed if he fulfilled the agreement.
Yes.
Okay. At this point, sentencing is still withheld, correct?
Correct.
And the maximum he's facing on count 30 is 15 years, correct?
Yes.
Okay. So right when he testified earlier today, he had a 15-year sentence hanging over his head as well as the probation.
Correct.
Okay. And so his maximum exposure is 15 plus 15, correct?
Yes. I mean, technically less, we'll say any time is already ticked off since the agreement. But generally speaking, it's 15 plus potentially another 15.
So, and at this point, if he's done a year on probation, it would be 29 years instead of 30 years.
Correct.
Okay. Now, you indicated in your review of the final plea agreement, there was one factual acknowledgement that you testified you missed, correct?
Correct.
Number 8 on the final agreement, you missed.
Correct.
And, well, I'm not going to ask you to speak on behalf of your client, but you missed it.
Yes, I can only say that I missed it. And had I seen that, I would have immediately, because it was of a certain subject that from the very beginning we had sought to exclude from this. But ultimately, for whatever reason, we missed it.
Okay. Can you, in sentencing acknowledgements, number 5 on that final agreement, defendant's sentencing acknowledgements,
Yes.
this final plea agreement between Mr. Sledge and the state, as reviewed by yourself and Mr. Sledge, indicates that your client is facing as much as 35 years in confinement. Isn't that correct?
Correct.
That's what the agreement says.
Correct.
Okay. In fact, he's facing 30, maybe 29.
Correct. It would have been a max of 30. So 35 was incorrect.
Okay. So,
Your Honor, I object to the characterization. The language, I'd object to the characterization, and I don't want to speak further, but the question was posed whether it said he faced 35 years, and that is an incorrect characterization. I can,
Okay, do you want to rephrase?
does the document say that if your client does not fulfill the obligations of this agreement, it may result in defendant being sentenced to serve as much as 35 years in confinement in the Georgia Department of Corrections?
That is what the document indicates.
Okay, is that your client is facing 35 years?
I think it would be a more correct statement to say 30, but point is 30 or 35,
Who cares?
a whole
Let's
lot of
go.
time.
Well-
But yes, I think the correct number is 30.
All right, you're making my point for me.
Gotcha.
You signed an agreement where your client was facing, you and your client signed an agreement saying that your client was facing 35 years.
Correct.
And he was really only facing 30 or less.
objection, asked
Okay.
and answered.
Yes.
Sustained.
Your client on that final agreement, there's a word that's crossed off and initialed by your client, correct?
Yes.
Okay, begin was changed to being. It's just switching the letters, right?
Yes.
Okay. And that was crossed out and written and initialed by your client, correct?
Correct.
All right, and you've reviewed the video tape. You were in here when the video was played
Well,
of your
yeah.
client taking a plea?
I was there.
Okay. That was something that Miss Love caught and instructed Mr. Sledge to cross out an initial, correct?
That sounds correct. Yes.
All right, that wasn't something that was caught by your client.
Correct.
Okay, Mr. Wright, you, in addition to what I first asked you about number 8, the portion of number 8 that you pushed back on the state and they changed, you also pushed back to acknowledgement number 3 on the final plea agreement, correct?
Correct.
And Your Honor, may I go back first?
Yeah.
Okay, and number 3, which you pushed back on, regarded the video that your client made with Quindarius Zachary, where he was, we'll say, threatening a gentleman by the name of Kelvin Watts, correct?
Correct.
Okay. And you're aware that the factual acknowledgement indicates that your client, while associated with YSL and to support and express loyalty to YSL, made this video.
Correct.
And it indicates, the acknowledgement indicates that the video was made on behalf of YSL, correct?
Correct.
Yeah.
Okay.
Your Honor, I'm going to object to characterization.
Sustained. I mean, if you read it carefully and then rephrase.
On behalf of YSL, defendant threatened to harm a person named Kel.
You can ask that.
Okay, but the acknowledgement indicates that on behalf of YSL defendant, that would be your client, Mr. Sledge, threatened to harm a person named Kel, correct? That's what the acknowledgement says.
Yes.
Okay, and you pushed back on that and you sent Ms. Love an email, correct?
Correct. Actually, we began taking issue with that characterization from the very beginning. And this was, I think I testified, an example of where we felt one way, the state felt another, and that was one of the examples where it was not changed.
Right. Okay. Do you have the emails? Actually, this might be.
460 is right here.
Do you have 460 in front of you?
Yeah.
No.
462, 461. One moment.
This is the only 460.
Ms. Love gave me this one. I'm going to
okay.
approach, if Your Honor will allow. I'm handing you what's been marked as 461.
Yes.
Going to read to you from your email what you said about acknowledgement 3 to Ms. Love. And this email was sent on December 27th at 8:43 p.m., correct?
Yes.
Okay, and this is the night before Mr. Sledge entered his plea, correct?
Yes.
Okay. You wrote regarding number 3, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the issue was the girl. Is that what you
Yes.
wrote? And is that verbatim?
Yes, that was verbatim.
Okay, so the point you were trying to get across is you're not denying that your client, Mr. Sledge, made the video.
Correct.
And you're not denying that he had an issue with Kel,
Correct.
but that issue was about a girl.
Yes.
And you ultimately, the state was unwilling to change that factual acknowledgement in the plea agreement, correct?
Correct.
They were unwilling to take out that it was done on behalf of YSL,
Correct.
and they were unwilling,
Your Honor, my objection is vague when the question is they were unwilling to take out that it was done. And earlier, Mr. Sharp referenced video. If you could just clarify what he's saying.
Sustained.
okay, they were unwilling to change the factual acknowledgments on your client's plea that he was to sign the next day, right?
Well, again, some changes were made, but as to that specific one,
I'm talking,
that was one example of where they were not willing to change it, even though we had a difference of opinion as to what it was about.
So the it is still unclear. So
And
if-
factual acknowledgement number 3, I'm sorry, yeah.
Okay.
Yes, my objection was could they specify what it we're talking about?
And it may help.
Factual acknowledgement number 3, which relates to the video that was made
Yes,
with your client and Mr. Zachary in it, correct?
yes,
Okay. The state was unwilling to change the language that it was done to support and express loyalty to YSL, correct?
correct.
And they were unwilling to change the language that it was done on behalf of YSL.
Correct.
And Your Honor,
Yes.
again, I object.
You can clear it back up on redirect, or are we already? Yeah, that was,
I haven't
you
done a
still have redirect, so you can clear it up then.
They were unwilling to change the language where it said, wherein on behalf of YSL, defendant threatened to harm a person named Kel because of that individual's association with a rival gang. They were unwilling to change
All
it,
right,
right?
all right. I think that the state's objection is a valid one, and I don't know if you want to, if you need direction, but
Thank you so much, Republic. Thank y'all so much.
Okay,
She
Attorney
literally,
Wright,
oh my gosh.
do you remember at this moment, in your email, you did not indicate specific changes that you wish to have made, correct?
I'm going to object.
Oh, for the love.
Actually, in my email, the way I even described I put, here are recommended changes, and then I went number by number, all the way 8 through 13 for the agreement I had at the time.
I get it. It's not like you went through it like you do in Microsoft Word and mark it with red or anything like that, like an editor would, correct?
Correct.
Okay, but the point you were conveying in that email was it was not gang related, correct?
Correct.
And it was over a girl.
Correct. As to that issue number 3.
As to number 3. Okay.
All right,
And
Shar, let's go, brother.
ultimately, the final version of Mr. Sledge's plea agreement includes language. You would agree that it includes language that indicates that the video and the making of the video and the threats were gang related.
Correct. That number 3 is an example where there was not a meeting of the minds with the state, and that's where they did not remove the information, consistent with what we were suggesting be removed.
And the gang related versus a girl was where the meeting of the minds was not happening, correct?
Correct. I mean, ultimately, the state included sort of both things in there where we were saying it was really about the girl.
Right. And you told Mr. Sledge that he could explain this later to a jury.
Objection, Judge. One that answered in province of attorney-client privilege.
That was asked and answered. Then attorney-client privilege.
Okay. Mr. Wright, from your dealings with Mr. Sledge, you are aware that Mr. Sledge did not completely agree with factual acknowledgement number 3.
Objection asked.
Oh
and
my
answered.
gosh.
Sustained.
On the date that he pled, he did initial that factual acknowledgement, correct?
Asked and answered.
Your Honor, this is the first time I'm questioning this.
I know, but lots of other people already have, and we've gotten that information at least a couple of times.
Okay.
I mean, you're welcome to ask whatever it is that you were leading up to.
I believe on cross, you indicated that in negotiations, you can't have everything, and sometimes you have to live with some things, correct?
Correct.
And your client initialing number 3, even though he didn't completely agree with it, is an example of having to live with things, correct?
I think I previously did state that number 3 was an example where there wasn't a complete meeting of the minds, but his choice was to either walk away and proceed with trial or enter into the plea agreement.
To go home, Mr. Sledge would have to live with that as part of the negotiations, correct?
Objection, Your Honor, that part is asked and answered. And-
Sustained.
All right, here's my question. Is it fair that Mr. Stillwell would have to live
Objection,
with your
Honor, asked
client?
and answered.
No.
I'm sorry. That is not what I meant to add. Objection, relevance, and improper question. Is it fair that Mr. Stillwell will have to do anything is an improper question for this witness. So forgive me for
Sustained.
Was Mr. Stillwell a party in these negotiations?
objection. That is, again,
I'll permit that question.
Was Mr. Stillwell a party in these
No.
negotiations?
And-
Was your
Char's gonna
client
yell, "Shut
signing
up,"
a
in a second.
factual acknowledgement that wasn't true? Is that something that Mr. Stillwell should have to live with?
objection. One,
Wow.
Sustained.
The signing of these incorrect factual acknowledgements, you would agree that it affects more people than just
Objection,
Mr.
Your
Sledge,
Honor.
correct?
Overruled.
I will state this. Any person in a case where there are multiple defendants, once they enter into a plea agreement that includes certain factual stipulations, that can impact all the defendants, not just themselves. So, to your point that yes, when Mr. Sledge was completing his plea, his focus was on him. However, there are effects or ramifications that could affect others.
And your
And
focus
Your
was,
Honor,
and
my
your focus
objection-
was
Hang
on
on just a
him.
second. Hang on.
and my objection was to the characterization of the incorrect or improper factual acknowledgement. So the answer, I think, sort of dealt with, but my objection was that that was a mischaracterization or improper characterization.
Was
All right,
factual,
well, the jury's heard the testimony, so.
was factual acknowledgement number 3 completely correct from your client's perspective?
We indicated that we took issue with some of number 3. Some of it we were acknowledging and some of it we took issue.
And he initialed it and he got to go home.
Correct.
Objection. that
And
was asked and-
it affects these other gentlemen back here,
He is
correct?
not caring.
Sustained.
No further questions.
Yo, hit that like for a deal with Christian. Yo, for a deal with Christian. Smash that bell for DWC. Yo, smash it, just smash it. Hit that like for a deal with Christian. For a deal with Christian. Smash that bell for DWC. Yo, smash it, just smash it. Hit that like for a deal with Christian.